Hello, welcome to Timmy Matt Law with me, Mr. McClellan. For this video, we are going to focus on a breach of the duty of care, looking specifically at the concept of the reasonable man. And just to emphasise the context in which we are covering all of this content, we are focusing on liability for physical injury and damage to property under the tort of negligence. Someone is negligent if they have done something which they really shouldn't have, or they have not done something which they really ought to have. Now, these 3 bullet points, these are crucially important to remember when it comes to determining liability for physical injury and or damage to property under the tort of negligence. Let's go through them. The defendant must owe the claimant a duty of care. Next bullet point, the defendant must breach their duty of care to the claimant. And then final bullet point, the breach by the defendant causes damage to the claimant. Now, it's so important that you remember each of those 3 bullet points in order, almost instinctively. And I will repeat them an awful lot. I always emphasise it so much to my students in class, constantly repeating them, writing them down on the board, and hopefully they will all sink into you because they're crucially important to remember. It is fairly logical stuff. The more we say it to each other, though, then the more likely you are going to grasp this content. So, the first point, of course, first bullet point, the defendant must owe the claimant a duty of care. And we covered this in our Duty of Care Explained video. If you've not watched it, you must go back and watch it before carrying on with this video. We know that in order to establish whether the defendant owes the claimant a duty of care, the neighbour principle must be established. Alternatively, you can employ the more stringent Papyri three-part test for those situations which are a little bit more unique and are not perhaps covered by the neighbour principle. So there's your starting point. You must be clear that the defendant owes the claimant a duty of care by applying the neighbour principle or the Papyri three-part test. Once you've done that, you can then move on to the next bullet point and work out some sort of answer to the query: has the defendant breached their duty of care to the claimant? If you know that the defendant owes the claimant a duty of care, you then must consider, have they breached their duty of care to the claimant? And then final bullet point, the breach by the defendant must cause damage to the claimant. This is focusing really on the issue of causation. You should be familiar with that principle of causation when you've covered it under the criminal context. It does work rather differently under the tort context, but at least at this stage you'll be able to understand what causation means. And that's really what this third and final bullet point is getting at. The breach by the defendant causes the damage to the claimant which they are seeking compensation for. Now, for this video, we are going to focus on the second bullet point. The defendant breaches their duty of care to the claimant. Now, if you need to know whether the defendant has breached their duty of care to the claimant, once you've grasped that the defendant does owe a duty of care to the claimant, you've got to appreciate what standard of care is required from the defendant, which they should show to the claimant. So whenever you consider, has there been a breach of the duty of care which the defendant must show or exhibit to the claimant, what standard of care is required? What threshold must the defendant meet? What is the expectation of the defendant when it comes to their conduct? So consider that particular question. Has there been a breach? Well, if there has been a suspected breach, well, what is the standard that we expect from the defendant? Well, the standard is according to that of the reasonable man. The standard of care is that of the so-called reasonable man. This fictional person who essentially represents all reasonable and right-minded people in this country. So the standard of care that's required of the defendant in terms of them showing a duty of care to the claimant is that of the reasonable man. And this concept of the reasonable man, it is an objective test. We'll come back to that in a second. So it's a dispassionate consideration as to what standard, what is the expectation of the defendant when it comes to them showing a duty of care to the claimant. What do we expect as reasonable people? Well, this concept of the reasonable man comes from the case of Blythe versus Birmingham Waterworks Company, 1856. It's a bit of an oldie case. Now, Birmingham Waterworks Company is responsible for supplying water to the houses of Birmingham, and that includes Mr. Blythe. Now, Birmingham Waterworks Company had fitted a plug to the hydrant from which water is supplied to people's homes, which actually failed. The plug failed and it led to the flooding of Mr. Blythe's home, and therefore he is seeking for Birmingham Waterworks Company to be liable for damage to his property as caused by the flood. Now, as a result of this particular occurrence, it was noted that the winter had been particularly severe, and indeed Birmingham had suffered from a very severe cold snap, and that caused the plug in the hydrant to break, which then caused the flooding and the damage to Mr. Blythe's property. And that is what the defendant, Birmingham Waterworks Company, focused on when it came to defending themselves against the claim by Mr. Blythe. They argued that they did everything that was reasonably expected from them in terms of maintaining the hydrant and indeed the water supplied to Mr. Blythe, but they couldn't possibly foresee such a cold snap which had affected Birmingham at that particular moment in time. It was a rather unique weather event, and actually it was found that the claim did not succeed against Birmingham Waterworks Company because they had done everything expected of them in terms of maintaining the water supply and the equipment, including the plug in the hydrant, to Mr. Blythe's property. They couldn't have foreseen the cold weather which would have so badly affected the water supply equipment. So the claim failed. There's a narrative of the case, but like so many of these cases, the important thing to consider is the principle that emanated from the case. No more so important than the concept of the reasonable man. And this is the wording of the judge, which was delivered as a result of the case of Blythe versus Birmingham Waterworks Company, 1856. The judge stated that omitting to do something a reasonable man would do, and it was considered that Birmingham Waterworks had not omitted to do something a reasonable man would have done. And indeed, kind of the opposite is also true. If you omit to do something that a reasonable man should have done, that could also include too that you have done something that would be expected of the reasonable man as well. So it kind of works both ways, whether you fail to do something or you have done something. If it's in accordance with the actions or indeed inaction of the so-called reasonable man, then no claim should succeed against you. So remember that principle, the concept of the reasonable man. It crops up so often, particularly under the content of tort that we're going to spend a significant amount of time covering. So you will be revisiting this concept of the reasonable man quite a lot. Have mentioned that the concept of the reasonable man is an objective test. You should consider it to be a rather dispassionate test. You shouldn't bring in your subjective opinion necessarily. You have to be objective when judging the standard of the so-called reasonable man. And indeed, the peculiarities of the person performing the task are irrelevant, okay? So even if the defendant has some sort of disability or some sort of personal difficulty, which they argued precluded them from carrying out a task effectively, that does not matter. It's all about what is the expectation of a reasonable person doing that particular task. So you don't necessarily focus on the specifics of the individual doing the task. It's about what's a reasonable expectation of perhaps anyone performing that task. And I think because of that standard, we are effectively keeping our standards in society rather high, maintaining health and safety and indeed decent conduct towards one another by essentially saying you cannot use the excuse that you find certain tasks difficult or that you really struggle with certain things in life. In essence, there are certain things in life that you have to do to a good standard. You have to do them reasonably competently in order to protect other people for the good of all society. So that's why the so-called reasonable man is an objective test, okay? Now, there are, however, 4 different types of reasonable man, and this adds just a little bit of context to the events that happen in everyday life, okay? So yes, we do have the concept of a reasonable man being an objective test. Yes, we emphasise that any task should be completed and performed reasonably competently, and yet we do allow for a little bit of an allowance when it comes to the specific or more specific context of certain situations. And because of that, we consider there to be 4 different types of reasonable man. And again, just like the 3 bullet points that have to be almost instinctive in terms of your recall, also the 4 different types of reasonable man have to be instinctive in terms of your recall. So let's go through them now. So the first type of reasonable man that we have is the ordinary person doing a task. And this really covers everyday occurrences, the things that we kind of do in our everyday life that we don't perhaps give too much thought to. We just get on with them because that's what we need to do in order to get through the day, essentially. So, by way of explanation, the defendant is expected to be a reasonably competent person, okay? And this idea of reasonable competency, the expectations of the so-called reasonable man, it's kind of that broad standard that we all have to meet in everyday life. And I guess in so many situations, we are effectively the ordinary person doing a task. We don't necessarily have specific skills in every area of life. We have a go at doing certain things. And you can see evidence of that in the case of Wells versus Cooper, 1954. And here you have a case where Mr. Cooper actually fitted a new door handle to his door, funnily enough. Now, Mr. Wells, who was a tradesperson actually visiting the home of Mr. Cooper, tried the door handle and actually leant back on it. The door handle came out and Mr. Wells fell down some steps, injuring himself, hence his claim for physical injury against Mr. Cooper. Well, Mr. Cooper argued, look, I'm not a professional carpenter, I'm not a professional tradesperson, I just needed a door handle fixing in my home, and that's the job that I did. So that was considered to effectively be the standard emanating from that particular case. The judge ruled that there was no liability found for Mr. Cooper. The claim failed against him simply because he had met the expectations of an amateur carpenter. Apparently, what Mr. Cooper had done wrong is not used the correct length screw to actually fix his door handle to his door. But he wasn't necessary to know that. He wasn't a professional carpenter, nor was he being paid. He was just fixing something in his house, and it was unfortunate that Mr. Wells was injured as a result of his somewhat poor work. But then again, you have to consider that he was just an ordinary person completing a task. And because he tried to do that to the best of his ability, the claim against him failed. So there's the ordinary person completing a task, the first type of reasonable man. The next type of reasonable man is the learner. Now, you would think that a learner has a lower standard of care with respect to the level of care that they have to show to a claimant because they're a learner. Well, it's not necessarily the case. There is a good reason for this. It may seem harsh, particularly, perhaps for people who are starting out in a particular career or profession or trying to learn a new skill. You may want that protection whereby you are told, well, you don't need to meet a certain standard just yet because you're only just starting out. Well, that's not necessarily the case. So, a trainee is judged at the same standard as the more experienced professional. And you may be thinking, well, how can that be? How can a trainee, someone who's inexperienced, be judged at the same standard when it comes to the duty of care they have to show to a claimant? How come it's the case that they have to have the same duty of care according to the standard of the more experienced professional? Well, I think the case of Nettleship versus Weston 1971 highlights this principle relatively clearly. So in this case, Mrs. Weston wanted to learn how to drive, and she asked Mr. Nettleship to teach her. Now, they were going to use Mrs. Weston's husband's car, and Mr. Nettleship had checked that he would be insured in using that car to teach Mrs. Weston how to drive. And indeed, Mrs. Weston will be insured as well in that particular vehicle. So they were driving along. Mrs. Weston was no doubt trying her best to drive correctly, but like a lot of learner drivers, she made a bit of a mistake, and she actually swerved the steering wheel. Mr. Nettleship couldn't correct her driving. He even tried to apply the handbrake to stop the car, but it was too late, and she crashed into a lamppost, and Mr. Nettleship, fractured his knee. So again, he's making a claim for personal injury. It was ruled, though, that there was liability for Mrs. Weston, even though she was a learner driver, and indeed that was her argument in court. I'm only a learner. How can you judge me against the standards of a more experienced driver, a driver who has actually got a driving license? I'm just learning. How can you judge me according to those higher standards? Well, think about it. If you get behind the wheel of a car, the risks against other road users and pedestrians are rather high. And you don't want to allow learner drivers crashing into people, injuring people, and therefore using the excuse, whoa, I'm only a learner, no liability against me, I'm just starting out. Given the nature of the risks when it comes to driving, everyone should be expected to drive safely according to the standard of a driver who has actually passed. Yes, we know that learner drivers make mistakes, but that's why they are insured. And indeed, Mr. Nettleship did check that the insurance would cover Mrs. Weston for the driving which she was doing in her husband's car as a learner driver. And indeed, that's why insurance is quite high, okay? So mistakes, of course, do happen for learner drivers. Mrs. Weston was found liable for physical injury caused to Mr. Nettleship. I imagine her insurance covered it, so therefore she hopefully didn't have too much of a negative financial impact, but it set the standard that when it comes to high-risk activities such as driving, even learners must be judged according to the same standard as a more professional driver. And also that equates to other professions, other jobs that people do, simply because we are looking to protect the greater good in society and to protect individuals in society. We cannot rely on the excuse that learners just aren't that good, okay? But again, there is the virtue of insurance. So there's your second type of reasonable man. Now the next type of reasonable man, and this is probably the hardest to remember because it includes the most detail, is the professional. Now straight away you'll be thinking, well, the professional must have quite a high standard of care, and indeed the professional will have a higher standard of care because they are a professional. They're trained to do a certain job, so they must surely do it reasonably competently. Now, a professional is judged by the same standard of a reasonable person of that profession, okay? And a really good example to focus on here is the work of medical practitioners, doctors. So, doctors, again, a high-risk profession. Mistakes will be made. It is obviously a question of life and death. So therefore, we can't just think about the standards of a ordinary person carrying out medical work, perhaps a first aider. Actually, doctors must be judged against the standards of other doctors within that profession. A reasonably competent professional within the medical profession. And again, that situation transfers to other professions as well, not just medicine. Anyway, let's look at the case of Boleyn versus Frierne Barnet Hospital Management Committee, 1957. Just to point out, Barnet is an area in North London. Frierne Barnet Hospital was actually a psychiatric hospital, no longer exists now. I think it has actually been converted into housing based on my research. But anyway, the case here involved a patient who had psychiatric illness, and therefore they were undertaking electroconvulsive therapy. Now, I don't think we use electroconvulsive therapy, so-called electric shock treatment, too much when it comes to treating psychiatric or mental illnesses now. But it would have been more common in 1957, and this indeed is what Mr. Boleyn is having done as a procedure: electroconvulsive therapy, electric shock treatment. Now, in giving Mr. Boleyn electroconvulsive therapy, electric shock treatment, his body was going to flinch quite significantly. It was going to react, obviously, to the electric shock. that he was given, and therefore that could have led to a risk of fractures. You can imagine someone's body jolting on a particular bed when the electric shock ran through their body. Now, the doctor actually considered whether to give the patient, Mr. Boleyn, relaxant drugs. Therefore, his body would go limp, and therefore, when his body convulsed, he wouldn't necessarily suffer any injuries. The doctor, though, in apparently weighing this decision up as to whether to give the relaxant drugs to Mr. Boleyn, did consider that by giving the drugs, there would be a slightly increased risk of death resulting from the drugs, I presume, side effects, and therefore it was decided by the doctor not to give the relaxant drugs to the patient. Now, as a consequence, Mr. Boleyn, upon receiving the electroshock therapy, his body convulsed and he did suffer fractures, a fractured pelvis, or a damaged pelvis at least, and he sought to make a claim of physical injury because of that against the hospital. It was ruled, however, that there was no liability for the hospital management committee, simply because the doctor, it seemed, had weighed up that risk. Yes, there was a risk of fractures, but let's weigh that up against the risk of death by giving the relaxant drugs, and therefore they took the decision not to give the relaxant drugs. Again, more significantly emanating from this particular case is the so-called Boleyn test. You've got to remember the Boleyn test, okay, and apply it to the reasonable man of a professional, okay? So the Boleyn test goes like this. Does the conduct of the defendant fall below the standard of the ordinary competent professional? I'll say that again. This is something that you're going to have to recite and remember. Does the conduct of the defendant fall below the standard of the ordinary competent professional? So that's the benchmark. Now, if the answer to that question is no, the conduct of the defendant did not fall below the standard of the ordinary competent professional, well, straight away, you don't need to go to the second element of the test. There is going to be no liability there. Test not satisfied. But if the answer is yes, the conduct of the professional did fall below the standard of the reasonably competent professional within the same profession, then you go to the next question. Is there a substantial body of opinion within the profession that would support the action taken by the defendant? So this is considering how other doctors would have reacted in the same situation or similar circumstances to the defendant. Now, if there is a substantial body of opinion that would support the actions taken by a doctor, for example, taken by the doctor in the case of Freehand Hospital Management Committee, then there would be no liability. In other words, the professional support is given to the defendant. It's what other doctors perhaps would have done, or at least they could understand why the doctor acted the way that they did. They may not have done it personally, but they can understand and indeed would support, would condone what the doctor or the professional had done, given the circumstances of the particular situation that they find themselves in. So that was the Boleyn test. Now, applying alongside the Boleyn test is also the so-called Bollinger principle, which adds another layer of complexity. It chucks out another question, and again, you're going to have to remember it. I'll come to the particular principle emanating from the so-called Bollinger principle in a second, but let's look at the case that gave rise to the Bollinger principle, and it's the case of Bollinger versus City and Hackney Health Authority Committee 1998. I always think it's good to give a location to any place names that we see. Hackney is a place in, I think it's northeast London, okay? So there's the area that we're talking about, and it was actually the claimant Patrick Bollinger, or at least the estate of Patrick Bollinger. Now, Patrick Bollinger, really sad case this, was a 2-year-old boy who had gone into hospital with croup. Now, croup is a respiratory illness, and it's characterised by a barking cough. It sounds horrible, croup. It's quite common actually in children, and you know, it needs treating, but it does sound horrible, and parents get very worried about it, quite understandably. So Patrick Bollinger was taken into hospital, and a doctor was required to treat Patrick Bollinger. Now, the doctor was called to do so. It does seem to be the case that the patient, Patrick, the 2-year-old boy did seem to be doing all right. But anyway, it seemed that the medical team were quite worried about the patient at this particular time. So the doctor was called to treat Patrick Bollinger, and the doctor did not actually come to treat Patrick Bollinger because the doctor's bleeper was low on battery, and therefore the doctor didn't actually get the call, so therefore didn't come to Patrick Bollinger to treat the patient. And sadly, Patrick Bollinger died. Now, Patrick Bollinger's mother argued that if he'd been intubated, so a tube had been given to her son, he may well have survived, and the doctor had failed to do that because the doctor didn't even attend to the patient when he was called for. And it was hoped that by intubating the patient, by putting the tube down effectively the throat of Patrick Bollinger, then I presume the breathing would have been done for him. Anyway, the doctor did not attend. Now in court, the doctor actually argued that even if they did attend and treat Patrick Bollinger through intubation, well, they wouldn't have actually decided to intubate the child at all, simply because there is a risk associated with intubating a small child. It can actually lead to death in itself or serious injury. Now, interestingly, from this case, 8 doctors were asked their opinion as to whether the doctor in this particular case had done the right thing, or claimed to have done the right thing by stating, look, even if I'd have turned up, I wouldn't have intubated this child anyway. Now, 5 doctors argued that given the same situation, they would have intubated the child, but 3 actually said, do you know what, I wouldn't have intubated this child given the risks. So whilst there was a majority out of the 8 doctors who disagreed with the actions of the doctor, or at least the argument they wouldn't have intubated had they turned up, 3 doctors effectively condoned the actions of the doctor, and that did recognise as a substantial body of opinion. The doctor in that case does have some medical opinion which is supporting their actions. And as a result of that, and this is the Bollinger principle, the standard proclaimed must be justified on a logical basis and be defensible. And it was thought, therefore, that this substantial body of opinion, it could be justified, logically speaking, and it could be defended, and therefore there was no liability for the doctor or indeed Hackney Health Authority Committee, City and Hackney Health Authority Committee in that particular case. Okay, so long as the actions of the doctor and indeed the substantial body of opinion emanating from the Boleyn test can be defended and justified on a logical basis, therefore there will be no liability with respect to medical professions. Now, final type of reasonable man, relatively straightforward. We've got young people, okay? Now, when it comes to young people, the standard is where the person is not an adult, i.e. they're a child, the standard expected is of a reasonable person of that age. And this is really suitably highlighted by the case of Mullin versus Richards, 1998. Kind of a tragic case in itself. You've got 2 15-year-old school children who are fighting with rulers. And when they're fighting with rulers, one of the rulers splintered off and actually blinded one of the 15-year-old school children. It was argued, though, successfully that the defendant couldn't have foreseen that the ruler would have splintered off and blinded the claimant, and therefore they were not liable for the physical injury of the claimant. And it was probably also considered that actually 15-year-olds do an awful lot of stupid things, and therefore you can't necessarily make them liable for all the stupidity in terms of what they get up to. So a young person must be judged to the same standard of care with respect to other young people and how other young people of the same age would have acted. I think a fairly common sense approach with respect to that final type of reasonable man. Now that's all the content that we need to consider when it comes to the concept of the reasonable man. I'm just going to give you a little bit of a prelude to the next video, which still is going to focus on a breach of duty. We though have to focus on risk factors, so look out for that. You can't just focus on the concept of the reasonable man. As important as it is, you've also got to look out for risk factors too, so watch this space for when I cover that content. Hope that was useful for you. Thank you very much.